Welcome back. Our Vox Pop of the week focuses on the issue of the vacation of judges. Some time back, a non-governmental organization, Access to Justice, had called on the National Judicial Council, NJC, to reduce the amount of vacation time judges cumulatively enjoy in Nigeria from 12 weeks to 9. Most of the courts across the country would be shutting down for vacation from Monday the 8th of July, and the vacation is generally expected to last for about 8 weeks. The judges also got a 2-week period during the Easter holidays and will get another 2 weeks during the Christmas holidays. Access to Justice in the past said that the Nigerian judiciary enjoys one of the lengthiest vacation systems in the world. The organization wants this to change. I got a few lawyers to comment on this issue.
I want to respectfully disagree with the NGO, Access to Justice. What we need, the solution here, is that let the NJC bring in more judges. Let more judges be appointed so as to attend to these cases. If more judges are appointed, I assure you, we'll have speedy access of justice, and the machinery of justice will grow exceedingly in this country. So I disagree with Access to Justice to the extent that the vacation period of judges should be reduced. Our judges are trying, they are doing their best. So if they are practitioners of the law, if they go to court as advocates, they would have known that our judges are doing their best. So they should be encouraged. Let's bring in more hands, especially from the legal profession. I mean, lawyers who are practitioners of the law. If we bring in more hands, the good for the society and the system of justice in Nigeria.
It is not easy because if you don't actually get to water, you don't know how to cross it. Not until when you had an appointment to become a judge or a magistrate, you will know what is involved there. And if they are not even the only one enjoying. Even with the lawyer, we even need the rest. So I agree that the 12 weeks is not too much. The 2 weeks for vacation is not cumulative. It's staggered. As a human being, they have to.
Cases are adjourned for 2 months or 3 months. Is that justice? What are you expecting the person in prison to think? That his case is going on nicely, favorably? No. The holiday is too long. I think they need to look into it, at least reduce it to an extent. That is my own opinion. At least if it should be splitted and reduced, at least, yeah. Because an average Nigerian like holiday, but these 2 months holiday at a stretch, well, it affects both the criminal cases and the civil cases.
I think we should take it systematically. If you say it's too much, that is a blanket statement on the judges. We have to appreciate what our judges are going through in this country. We have to appreciate the volume of workload in our courts. You need to visit a judge on a day to see what the judges are passed through. And don't forget that the judges are doing academic work. They work throughout the court. When they get home, they have no time for their family, they have no time for themselves. They continue to work. At night, they wake up and work. By 5 o'clock in the morning, they start preparing and they go. So that is what they work throughout the clock. It's not an agent. They are human beings like us, so they need rest. For them to rest 3 months, cumulatively 3 months in a year, it's not too much for them.
And just before we go, the Legal Practitioners Privileges Committee, LPPC, has conferred the rank of Senior Advocate of Nigeria on 38 persons. They'll be sworn in at the start of the new legal year after the vacation, and we'll keep our eyes on that one. Let's now bring you a quick recap of some of the top trending stories from the courtrooms.
We begin with the report that the Supreme Court on Friday, July 5, upheld the return of Governor Adegboyega Oyetola of the All Progressives Congress as the governor of Osun State. The court dismissed the appeal by the candidate of the People's Democratic Party, Senator Ademola Adeleke. In a majority decision of 5-2, read by Justice Bode Rhodes-Vival, the Apex Court held that the failure of a member of the Election Tribunal, Justice Peter Obiora, to sit on February 6, 2019, rendered the entire proceedings and the judgment given by the tribunal a nullity. The Supreme Court also agreed with the appeal court that the absence of Justice Obiora when a key witness in the petition was heard meant that the tribunal lacked the authority to have given any judgment on the matter. Justice Rhodes-Vival said that it is settled in law that when the rightly constituted panel of a court does not sit, the activities carried out by that panel is a nullity. The acting Chief Judge of Nigeria, Justice Tanko Mohammed, and 3 other members consented to the leading majority judgment, but Justice Kumai Akas and Justice Paul Galinje affirmed PDP as the winner of the poll. Justice Akas, in his minority judgment, held that the Independent National Electoral Commission in an election ought to remain an unbiased umpire because even when it erred in law by relying on its manual to cancel some aspects of the election, the applicant still met the constitutional requirements of having the highest votes cast and spread. But the election umpire went ahead to cancel the election and carried out a rerun, showing that INEC had a plan up its sleeve. In Lagos, the Federal High Court ordered a permanent forfeiture to the federal government the sum of $8.4 million and another 9.2 billion naira linked to the wife of the former president Goodluck Jonathan, Patience Jonathan. Justice Mojisola Olatoyegun held that she failed to show reasonable cause why the funds should not be permanently forfeited. The court found that the funds, as claimed by the Economic and Financial Crimes Commission (EFCC), were reasonably suspected to be proceeds of crime pursuant to Section 17 of the Advance Free Fraud and Other Related Offences Act 2006. Though Patience Jonathan, through her lawyers, Ifedayo Adedigbe, Senior Advocate of Nigeria, and Mike Ozekome, Senior Advocate of Nigeria, insisted that the funds were legitimately hers, the judge held that respondents failed to dispel the suspicion created by the movement of the monies within the meaning and contemplation of the Advance Free Fraud and Other Related Offences Act. Apart from Patience Jonathan, other respondents in the application for the permanent forfeiture of the funds were Global's Integrated Services Limited, Finchley Top Homes Limited, AMPM Global Networks Limited, Pagmat Oil and Gas Limited, Miguel Resort Limited, and Esther Oba. The EFCC, through its counsel, Mr. Rotimi Oyedepo, said the respondents were not into any legitimate income-yielding business venture as to earn such amounts. A day after the order of forfeiture, the firms which the EFCC alleged were incorporated for warehousing the proceeds of unlawful activities for Mrs. Patience Jonathan filed a notice of appeal against the judgment of the Federal High Court, Lagos. Marjo Resort Limited, joined by Finchley Top Homes Limited, AMPM Global Network, and Magmat Oil and Gas Limited, challenged the decision of Justice Olatoyegun. Through their lawyer, Mr. Michael Zekome, Senior Advocate of Nigeria, they filed 6 grounds of appeal and argued that the court occasioned a miscarriage of justice when it assumed jurisdiction to hear the motion for the final forfeiture of the funds after relying on the speculative depositions of the EFCC. The firms want the appellate court to set aside the lower court's order and return the forfeited funds back to their accounts. Another federal high court sitting in Lagos on Friday ordered the interim forfeiture to the federal government some expensive jewelry valued at about $4 million, which were recovered by the Economic and Financial Crimes Commission in the premises of a former Minister of Petroleum, Diezani Alison Madueke. Justice Nicholas Owoibe made the order after granting an ex parte application brought before him by the EFCC prosecutor, Rotimi Oyedepo. In the application, the EFCC says the expensive jewelry comprising wristwatches, necklaces, bracelets, bangles, earrings, a customized gold phone, and more were reasonably suspected to have been acquired with proceeds of unlawful activities of the former minister. The former governor of Ekiti State, Ayodele Fayose, has been rearraigned before Justice Chukwujeku Aneke, also of the Federal High Court in Lagos. The rearrangement followed the reassignment of the case to Justice Aneke after the Economic and Financial Crimes Commission expressed loss of confidence in Justice Mojisola Olatoyegun, who was previously handling it. Fayose was first arraigned on October 22, 2018 on an 11-count charge of receiving and keeping 1.2 billion naira and $5 million stolen funds from the Office of National Security Advisor, contrary to the Money Laundering Act. He was arraigned alongside a company, Spotless Investment Limited. At the rearrangement, Fayose again pleaded not guilty to the offense. His counsel, Ola Olanipekun, Senior Advocate of Nigeria, applied that he should be allowed to continue to enjoy the bail earlier granted by Justice Olatoyegun. EFCC counsel Adebisi Adeniyi raised no objections, and Justice Aneke subsequently admitted the former governor to bail in the terms and conditions earlier granted by Justice Olatoyegun. Justice Aneke also ordered the release of Fayose's passport to enable him travel to South Africa for medical treatment. Trial was then fixed for September 16. And we round up with a report that the trial of the president of the Nigerian Bar Association, Paul Usor, Senior Advocate of Nigeria, has started with the Economic and Financial Crimes Commission, EFCC, calling its first prosecution witness. Before this, Justice Rewan Aikawa struck out an application filed by the governor of Akwa Ibom State, Udom Emmanuel, seeking to stay the proceedings and adjourn indefinitely pending the verdict of the appeal court on his challenge to a decision delivered on the 30th of May. On that day, Justice Aikawa had dismissed the governor's application challenging the court's jurisdiction to hear the money laundering charge filed against the NBA president. Justice Aikawa held that Governor Udom's application lacked merit because he was not a party to the suit. After resisting the move to adjourn the proceedings, the court ordered the EFCC to call its first prosecution witness. The first prosecution witness, Udom Idongeset, a relationship manager with Zenith Bank, Uyo Akwa Ibom State, told the court that she came to open an account for the defendant, Mr. Paul Usoro. She testified that in March 2016, the bank was given withdrawal instruments of 700 million naira from the impressed account of the state government. 300 million naira out of the money was signed for and collected by Margaret Thompson Ukwe, an employee of the state government. The court has adjourned till the 21st of October for the continuation of trial.
And that's the program this week. You can watch it again on our YouTube channel. Kindly give us feedback via any of our social media handles. I'm Shola Shayeli. Thank you for watching.